Welcome everyone to Office Hours with whistleblower attorneys Renee and Eva. Today we're going to go through some FAQ questions about the False Claims Act and everything you ever wanted to know about being a whistleblower on government fraud. So just a few housekeeping items. Everyone is on mute and in listen-only mode. This webinar is being recorded and the recording will be available at fraudfighters.net/office-hours in about a day after this event. Please type your questions into the Q&A box at the bottom of your Zoom screen and check the Ask Anonymously button if you want to remain anonymous. And so without further ado, welcome to our monthly Office Hours webinar.
Hi, welcome everybody, and thank you for joining me and Eva. This is our Office Hours with whistleblower attorneys, Renee and Eva, and I'm Renee Brooker, and this is my partner,
Eva Gunasekera. Hi, everybody.
Just to give you a little bit of background, I spent my career as a prosecutor at the Department of Justice enforcing the False Claims Act, and now I represent whistleblowers. And Eva can introduce herself.
I had the privilege of working with Renee at the Department of Justice in the Senior Counsel for Healthcare Fraud capacity, and I'm now in private practice with Renee representing whistleblowers.
So we're thrilled to have you all here. We have a lot of folks who joined, and we are happy to take your questions. And I'm going to make sure I know how to do that. I'm clicking the Q&A box so I can see if you have questions. What we're going to address is, let me just sort of give everybody an outline for this next hour. We're going to cover basic topics and assume that most people who are listening are not expert in the False Claims Act, but we're happy to take deep questions as well. We're going to address what's the False Claims Act and exactly what does it cover, what is a key TAM suit, and who can bring one of those under the False Claims Act, what monetary rewards whistleblowers can receive for filing a case, and what kinds of information you need to bring a case, and whether or not you should have an attorney or you should go it alone. We'll also address what kind of retaliation protections there are for whistleblowers. And then probably halfway through, we're going to talk about 3 types of fraud cases that we are used to seeing on a regular basis, just to give some perspective on the types of work that comes under the False Claims Act. And we're going to talk about healthcare kickbacks in the entire healthcare industry, which is a really common fraud scheme that DOJ enforces. We're going to talk about DOJ's exciting new False Claims Act civil cyber fraud initiative. And then we're going to talk about a fairly new, or maybe it's newly used whistleblower program that the Department of Transportation has for its Motor Vehicle Act. So that's a big agenda. And we, like I said, the last one that we did, we had a lot of questions, and we're really thrilled to field questions. So I guess we'll get started. And I will just start with what is the False Claims Act. And the False Claims Act is a law that allows in the government, and it's always the United States Department of Justice that files the lawsuit, to pursue a company for committing fraud against a government program. So as I always explain to people, these are taxpayer funds that are being protected by the False Claims Act. And so if you think about what types of programs are funded by taxpayers, it's pretty massive and broad. When you think about the Medicare and the Medicaid programs, any kind of fraud directly or indirectly by a company, a healthcare provider, a hospital, a laboratory, a pharmaceutical company, durable medical equipment company, anyone in the healthcare industry is subject to the False Claims Act, and particularly all those types of companies. Also, the government awards billions of dollars annually in contracts and grants. So the Department of Defense, for example, has huge government contractors that do everything from protect government cyber security systems to build planes and warships and just about every kind of product and service you can think of. The the government is usually contracting for it and not doing that work itself. So those, all of those types of industries are subject to False Claims Act enforcement. And I'm going to let Eva address what is a key TAM suit under the False Claims Act and who can file one of them.
And before I do, actually, Renee, I think your explanation was really helpful, and maybe even to put a finer point on it. There's often confusion, and I understand why, as to who are the defendants, who are the parties that are at fault. And sometimes there's confusion because we hear from whistleblowers who think that the government itself and the government agency may have fallen down on the job, and they come to us with legitimate concerns, but they're focusing on the agency itself who paid for the contract, or who paid for the services, or who paid for the healthcare provider. Can you maybe just elaborate on who are we talking about when we're talking about a party who has defrauded the government from taxpayer funds?
Yeah, it's a great question, because often we do have whistleblowers who work for the government even, and come to us and they say,
That's right.
there's fraud happening inside the agency that I'm working on. So the False Claims Act it's not a statute that is intended to capture all fraud in the entire world against any entity, including, fraud, waste, and abuse that occurs within the government. It is a broad, incredibly broad enforcement statute, and it's very powerful and recovers lots of money for the government. But the defendant is always going to be a recipient of government money, either directly or indirectly. And so when I say directly, I mean, as just an easy example, a government contractor, someone who is a big entity. These are usually, entities. Individuals are also subject to liability, but the Department of Justice, the vast majority of its work is against entities. So government contractors are always directly getting government money when they have a government contract, and they need to perform on those government contracts in accordance with the contract, the contractual requirements, the government specifications of the contract, all laws and regulations that apply to the government contract. And so in that example, a government contractor can be a defendant. Also, when I say indirectly, I'm thinking about entities such as pharmaceutical manufacturers. So all of your big drug manufacturers, every one of them is making drugs for patients under the Medicare and Medicaid programs. And there are also other taxpayer government-funded programs for healthcare, like the VA, and all federal employees, which is a significant number of people in the United States, are covered by the federal healthcare benefits program. So any Medicare, Medicaid, VA, FEHB, and TRICARE for military members and their families, all are government taxpayer funded programs. So any entity in the healthcare industry has to comply with the False Claims Act. And again, going back to the indirect entity, a pharmaceutical company is never, they don't have patients, right? They're not the kind of healthcare provider that is taking care of patients and directly submitting a claim to Medicare for the services they're providing. That doesn't happen. Instead, for example, pharmaceutical manufacturers are making drugs that are then prescribed by a physician and filled at the pharmacy. But just because the pharmaceutical manufacturer is not receiving the money for the patient, they are still subject to and liable under the False Claims Act, because if they commit fraud, they violate rules and regulations, and they do so knowingly. They can cause the physician to prescribe a drug that is a false claim, or a pharmacist to fill it. And that's just one example. So, and I use those examples because, again, the False Claims Act is very broad, but a defendant is always going to be an entity that is getting government money directly or indirectly. And I don't know.
That was a terrific explanation. Thank you. And I think that's a really important point to make, because even if the government agency itself may not have followed through on monitoring or paying, close attention to all the invoices or all the claims that are being submitted by the private party that's receiving those government funds, it doesn't mean that that private company or that government contractor or that pharmaceutical company isn't liable under the False Claims Act. And so I think that's an important distinction. But picking up, Renee, on your question about what is a qui tam lawsuit and who specifically can file one, qui tam is actually an old Latin phrase. What that means, a lawsuit that's brought by a private party on behalf of the government. So another way that we think of qui tam lawsuits is an individual, a private person who's standing in the shoes of the government and alleging fraud on behalf of the government. And we can get into the specifics of how a qui tam whistleblower works hand in hand with the government later this hour or during another office hours episode. But that private individual is often called, and under the law, under the False Claims Act, is called a relator. Not a realtor, which is a common mistake that folks use in our space, and we get it because it's spelled very similar, but a relator is a qui tam False Claims Act whistleblower.
I found something more creative, Eva, under the statute than calling our whistleblowers relators.
I don't, that's a really good point. I always wondered, what is the derivation of that term? I don't know. So we'll have to add that to our homework list. But the importance of the whistleblower, and this actually dovetails with one of the questions from one of our participants in the office hours, is, and the question is, do you have to be an insider to be a whistleblower? And the answer is not necessarily. And actually, the more pointed answer is no, you do not have to be an insider. But what you do have to bring to the government is non-public information about the fraud. And ideally, it's non-public information that is documented or memorialized in some kind of documentation that the government would otherwise not be privy to. So what I mean is, while anecdotal evidence and witness testimony is key to these types of cases and proving these types of claims, it's really the documentary evidence that you may have that the government otherwise would not be aware of, that is the way to really stand your ground as a meritorious relator under the False Claims Act.
So Eva, let's say you're a business operating in a certain space, and you know that one of your competitors is cheating the government, and maybe because you have strong circumstantial evidence, or maybe you know because your customers in the same space are telling you how your competitor is operating. Are you allowed to be a competitor and file a False Claims Act case as a qui tam whistleblower and get a reward?
Yes, you are, and it's been done. And those competitor relators have helped the government in getting money back that otherwise shouldn't have been paid. And in certain instances, those competitor relators also receive what's known as the whistleblower reward under the False Claims Act, because they were bringing information to the government about fraud that they were aware of based on non-public information in the course of either their customer relations or just their involvement and work with that competitor in the community. And so, yes, that is a valid relator. And I think actually in this day and age, we're seeing more what I would consider non-conventional relators. So back in the day, a relator was typically an insider, somebody who was an employee of the company, and it was the company who would have been the named defendant in the False Claims Act case. It was the company who would have been defrauding or allegedly defrauding the government of its funds. And that person was, quote unquote, a true insider. They're literally inside the company coffers, and they're able to get company documentation and bring forth evidence of fraud that the government would otherwise not have been aware of. Now, what we're seeing, in part because of the exchange of information and kind of the kind of wealth of just electronic, the communications, you now have more and more people who are knowledgeable about the industry and have inside information just based on their expertise. And that's just as valuable to the government. The government can't be an expert in all the federal agencies' business. When you think about all the federal agencies who hand out government money, it's quite a bit, and it runs the gamut in terms of Department of Transportation, Department of Energy, EPA, in addition to, of course, Health and Human Services, Department of Education. There's just so many agencies, and all of those agency programs have a level of expertise in terms of what they are paying for in terms of services and products. And so a whistleblower or relator can also be, in our opinion, an industry expert who has inside information in terms of the way that the industry works and is able to take a lot of data or a lot of information and compile it in such a way with their expert analysis that it shows trends and patterns of fraud. And that's really all the rage right now in terms of data analysis in the healthcare context. There is a lot of initiatives both within the Department of Justice, which is the agency that's charged with enforcing the False Claims Act on behalf of all the other federal agencies, and even in the relator community on data analysis and the importance of looking at patterns and practices in, for instance, the Medicare and Medicaid data to identify outliers. Physicians, companies, entities who seem to be receiving an exorbitant amount of funds, healthcare insurance funds for services where there's serious question as to the legitimacy of those services and the excessiveness of it. So there's just so much to be done in this space in terms of kind of the creativity and who and what a relator can be. But really at its base, typically relators are considered to be insiders of a company, but that's changing in this day and age.
And so Eva, do the whistleblowers need to be somebody, at a high level within the company? If it's a large company, do they need to be a senior VP or a VP? Or if they're at a hospital, do they need to be a hospital administrator? What, qualifications within the company is necessary or required to be a whistleblower?
It's a great question, actually. The quick answer is no. You don't need to be in the C-suite in order to attach False Claims Act liability a Fortune 500 company. In fact, some of the biggest pharmaceutical settlements under the False Claims Act in the last 30 years were brought by the boots on the ground, the sales representatives in those companies who had knowledge of illegal practices like kickbacks that were being provided to physicians in exchange to, with the expectation of inducing those physicians to write false claims and cause false claims to be submitted to the Medicare program. And they were literally just in their lane, in their region, observing these practices and brought that information to the government. And those led to be frank, some of the biggest False Claims Act billion-dollar settlements that the DOJ has resolved with those pharma companies. So you don't need to necessarily be an executive or even a mid-level manager. If you observe practices in your workplace, either inside your company or with a competitor or as a third-party vendor that appear to be illegal, really it's important that you speak to an attorney who practices in this space and have a frank conversation about it to better understand whether or not you might have a False Claims Act case.
Yeah, and it's, we have a lot of whistleblowers, right, Eva, who are nurses.
Yeah. That's
Again,
another great example.
Nurses at healthcare providers and hospitals. And, when we say that the conduct needs to be fraudulent or illegal, those are kind of, to a lot of people, those are intimidating sounding words. And really what we mean is if the company you're working for, is violating contract terms, if they have a contract with the government, or they are violating rules and regulations, like in the healthcare setting, if they're violating Medicare and Medicaid rules, and they are doing so knowingly, it's not inadvertent, they know that they are. Let's say you have a hospital that is audited every year and the same findings come up year after year, and they continue to have those findings. They do not address those findings. Others at the company who are looking at audits know they have those findings. They don't repay the monies under those audit findings to the government. All of those are examples of, potential False Claims Act violations. And so it doesn't, illegal does not mean criminal, right? And fraudulent does not mean criminal. It really means knowingly violating rules and regulations or contract provisions, or any other kinds of requirements that are imposed by the government on an industry. And there has to be some loss to the government. So like just to give an example, I on occasion, we have patients who will call and say, a Medicare provider won't see them, won't offer them services, that you may have some other issue and you may want to report that to a state regulatory body, but there's no false claims there because Medicare isn't paying services. In fact, their complaint is that they can't get the services, even though they have Medicare insurance. So there has to be some financial harm to the government. And that doesn't mean the government has to pay out money, because sometimes the government has other objectives, like in the small business context, where the government wants to award contracts to small businesses to encourage them to grow and become larger business and successful businesses. And even if someone is cheating the small business program, but still performing the work, the government's larger goals of awarding contracts to small businesses may be violated. And so that is also a potential False Claims Act case, even though there's the contract that's actually the work has been done and been performed, you can still assess damages in a case like that. So
yeah, that's right. Another good segue with a question from one of our attendees is, if you choose to become a whistleblower, what type of protection do you receive for bringing a case, since you're effectively speaking against your employer, your boss, even if it's a competitor or you're a vendor speaking against a client? How can you be protected, or why would you do that?
So there's really two sort of phases of, I guess, protection or being retaliated against that I think of. Some clients come to me and Eva, and they say that they have raised concerns within, let's say it's a healthcare provider. They work for a healthcare provider, and they are seeing that there are continual violations of Medicare rules, or Medicare is being billed, for example, but the patient services aren't being provided, or a certain service is being provided, but they're billing Medicare for a higher service, a more costly service, just as one example. And they have been raising this over and over again, and they have been retaliated against. So sometimes they come to us and the retaliation has also occurred. And retaliation really under the False Claims Act is defined very broadly. It doesn't necessarily mean you've been fired or you've been assaulted. It really is quite broad. You could be demoted or just marginalized or ridiculed or put on some kind of suspension, or even just ignored. Your claims are being ignored, and you're being belittled, all the way to you've been terminated or you've been forced out. So some of our clients have been retaliated against, but they felt that they were forced to quit. And so that's called constructive discharge instead of you're actually given a pink slip and told to leave. All of those types of actions, if you are having those occur to you in response to or concerns that you are raising, even though you don't know what the False Claims Act is. A lot of people come to us and they say, I'm worried about my, nursing license because I think I'm doing something I shouldn't be, and I've raised it. I'm on the threat of getting fired, and that is a retaliation claim you have under the False Claims Act. And so if you have a valid whistleblower case, your attorney may file also a retaliation allegation, and you're entitled to recover what you lost as a result of being demoted or terminated or forced out of the company. And so all of those things fall under retaliation. But then there's the other end of it. So we also have clients who come to us who haven't been retaliated against. They are raising these concerns, and they, business as usual is going on. And a lot of times people come to us because they are concerned about their own liability. Lots of people don't come to us. In fact, most of them don't come to us because they know about the False Claims Act. They come and they say, I am afraid that I'm going to be liable for what I'm seeing in my workplace. So I don't know, what should I do? And we talk about all their options. And one of them might be, if they have the evidence, to file under the False Claims Act. And then they're concerned about, well, will I be retaliated against when and if I do that? So sometimes the retaliation fear or threat is in filing the False Claims Act, and not has already occurred by the time they, have filed and came to us. And so the False Claims Act protects that as well. So you can't be fired or terminated for filing a False Claims Act. And in fact, and I have clients who have longtime False Claims Act investigations, and they remain employees during the course of their under seal, under investigation lawsuit. And sometimes we have some clients who have settled with the company, gotten a reward for the settlement, and they continue to be employees at the company, even though they filed a lawsuit and alleged fraudulent conduct, and the government gave them a settlement. They continue to be employees there. So a lot of employers are, very aware of the False Claims Act and appreciate that they cannot fire an employee for that. So retaliation can come in, in terms of the time when you're retaliated, can run across the gamut, but you are protected at both ends of that. And so if you are concerned about those issues, you should definitely speak to an experienced False Claims Act lawyer about your exact situation, because everybody's different, right? Everybody's in a different industry, at a different company. We have some employees who are very marketable. So software engineers, some of our clients are, and they can get employed tomorrow. They can quit their job today and be full-time employed tomorrow. So they have less concern maybe about whistleblowing. They don't feel as at risk, whereas there are some individuals in other industries where if they lose their job, they really could be out of a job, and really have a hard time getting back into their industry. So we really talk to everyone individually. There is absolutely no one size fits all, and we need to know more about your specific scenario, your specific industry, your company. And those are issues that we really have a dialogue about with the whistleblower before we advise them on retaliation.
And another unique, I think, protection that's embedded in the False Claims Act is the fact that the cases, when they are filed under seal. And so, Renee, you mentioned this in passing, and we mentioned it during our last episode of Office Hours, but it's worth repeating because it's really a unique aspect of the False Claims Act and any False Claims Act lawsuit. Most people are familiar with criminal and civil cases that are filed publicly, and a news reporter could pick it up. Anyone could become aware of it, particularly if you're in a small geographic region. We know clients who are concerned about that, and legitimately so. But what's especially unique about the False Claims Act is the case at the outset is filed under seal. Now, eventually, it will come out from what we call out from under seal, which means it will be made public. And to the extent that there is a lawsuit that's filed by the United States or a settlement, there may be an announcement, an accompanying press release that goes with the case. Those are usually happy events for the relator whistleblower, because they usually either have convinced the United States that there is fraud at issue here, and or have resolved the case and brought money back into the government. So those are happy moments, but it is worth noting that you don't know where your career path is going to go. And these investigations can take years. And usually that period of time is under seal. Now, eventually the government becomes aware of the investigation, not the government, excuse me, the company becomes aware of the investigation, because the government approaches the company to request documents, witness testimony, and the like. But the existence and the knowledge of the specific relator is sometimes kept and remains confidential, even in those conversations and that dialogue with the company, because it's not necessarily in the government's interest for the company to be aware of who the relator is and to otherwise focus all their energy on that person. The government isn't really interested in that backstory. The government is interested in, how was this federal agency defrauded? How do we recoup money that this company otherwise shouldn't have been paid? So it's really, truly a unique kind of a whistleblowing type of a case, because of that brief period of almost anonymity for the relator that allows you, maybe to the extent that you are on your way out or were already looking to go on your way out, be in a little bit more of a position to take your time, I guess, in terms of what you decide to do. But along those lines, Renee, why do you think whistleblowers file these cases based on your experience?
In almost every case, Eva, that you and I have vetted, where we have spoken to a whistleblower, they usually, by the time they have come to us, they are very concerned and very stressed and deeply troubled. And so most of the time, if not all of the time, they have been thinking about these issues or problems for a period of time, and they are losing sleep. They are concerned about, often they're very, very concerned about their own liability, because anybody who is an employee of a company who is thinking about whistleblowing, because they have the information, it means they're in the middle of it. They're right in the midst of whatever is concerning them. And so that is a very stressful situation for people to be in. And so they often seek us out and they ask us in the first instance, am I protected from what's happening at the company? Am I protected, against the law? Is the law going to come after me? Am I going to be retaliated against at the company if I continue to raise these issues? And they really just want to do the right thing. Most of our whistleblowers say to us, I know there's a reward involved, but I'm really not here just for that. I am very concerned and I want to do the right thing. And we see people really in a very bad place most of the time. And some of them are angry, frankly. Those who have been raising the issues internally and are being ignored come to us kind of angry as well, because they've been trying to have management correct the situation. And so they feel like management has forced them to take this step that they really didn't want to take. They really don't often want to be whistleblowers. Instead, they wanted management to do the right thing, and management doesn't. And so it's, you kind of feel like, how is it that I am now in this place where I need to go outside of my company and report this because my own company won't do anything about it? So that's the place that most people come to us. Competitors are very different. Competitors have a keen sense of unfairness for themselves and others in their space when they see that fraud is being committed by someone else in their space. And so kind of like, I often think about it as doctors. Most doctors are good and they are happy when the bad doctors are weeded out of their profession. And so competitors have the same sort of sense, like, wait a minute, for me to be competitive and continue to have a business, I need a level playing field, and this bad apple shouldn't be playing in our field. So often the competitors who come to us, they are, they are angry on behalf of themselves and others in their space that are conducting business fairly and not cheating, not doing an end run around whatever the government rules and requirements are. So our clients really come to us in many different sort of frames of mind.
Well, I think that's a really, really important point, because we have worked with some international whistleblowers, and there is this misconception, I will say, about whistleblowing and how you're really telling on your colleagues. There's this sense of like, I'm being a tattletale. And I don't want to have that association. I'm throwing my good, my work buddies under the bus.
And what do you say to that, Eva?
Well, and so I like the way that you spoke about this, because it's actually a whistleblower is trying to make their whole industry and their whole profession better. They're actually trying to support the good guys in their workspace. And that's really an important theme that we can't stress enough. I was surprised, I'll say, Renee, when we have worked in the international space on whistleblowing type activity, which we've had the privilege to do. I was really surprised, even in what we would consider like Western nations. That's not a great term, but like Europe, for instance, there is still an extreme negativity associated with whistleblowers. And to be frank, I was disappointed because you can see in the United States that there has been so much really progressive development when you have these settlements announced. You have the entire industry kind of looking up out of their space and realizing, wow, there are bad actors and bad practices, and we need to be aware of that, and we need to not do that and avoid those kinds of problems. And you really actually see entire industries change their practices because of False Claims Act settlements. That's the effect and impact that these types of enforcement efforts have. And I think if those enforcement efforts were to take hold in Europe and Asia, Africa, really everywhere, I think those industries would view whistleblowers in a totally different light. And so we really actually have quite a bit of work to do. Even in the United States, to be honest, Renee, I think you mentioned on the last office hours about the Facebook whistleblower. Yep. And how there had historically been, a negative, almost like a negative aspersion, like attached. I'm thinking of, this isn't exactly an on-point parallel, so I'm sure you'll find something else, but like Anita Hill and the Clarence Thomas nomination, she was really demonized for kind of coming out. And I know that was a totally different kind of fact pattern that we don't address on a daily basis. But the point is, anyone who's coming out and kind of pointing the finger at their own is immediately demonized as disloyal. And it's really only recently that we're beginning to appreciate the importance and the bravery and the integrity of whistleblowers who do that, because it's not easy to be a whistleblower.
Yeah, I mean, I do think they're gaining respect, and I think there have been different whistleblowers along the way who have helped along the concept of the importance of whistleblowing, including the Madoff whistleblower, who, as you and I know, we talk about it all the time. We face it sometimes in certain of our cases that we develop, where he knew what he was talking about. He knew that Madoff had a Ponzi scheme, and he repeatedly went to the enforcement agency, and he had the numbers, he had his analysis, he had data, he had the ability to back it up. He wanted an audience, and he was really, not paid attention to. And I think that after the whole Madoff debacle and so many people lost their life savings, I think he made strides in the importance of like listening to people who are stepping up and speaking the truth and saying that they've done the analysis or they have the inside information because they're inside a company. And then Frances Haugen, the Facebook whistleblower, was tremendous. I think I've said to you and others before, I watched her congressional testimony, and she was very clear about, the contours of what she knew. And she shed light on practices at Facebook that we could not know. We would not have known, but for somebody inside the company with the knowledge stepping up and bringing it to light. And it was something that I think a lot of people suspected about issues that were happening inside Facebook. But she was very articulate and non-defensive and open about her information and her knowledge and her sense of, right from wrong, and wanting to, make a difference and a change. And money was not an issue for her. It was a do the right thing kind of mentality. And, she had concerns of consumers and, children consumers of Facebook, and she had a lot of very specific information that was helpful. So, I mean, that's why you and I are here, Eva, because, we as former prosecutors saw the value add to whistleblowing, and we saw that the government was recovering billions of dollars of misspent funds because of or thanks to whistleblowers. So and that's why we wanted to step outside and represent them in the way that we had worked with them while we were at DOJ. So yeah, I think we believe in whistleblowing, and if you have the right attorney, someone who is understands this process and is going to weed out the good and the bad cases and make sure that only those meritorious ones are being brought and investigated by DOJ. I think you have a very valuable service and a system, and it's important. Whistleblowing is important. It should be important to companies themselves, because most companies want others in their space to be on a level they want a level playing field, and they want other businesses to conduct themselves the way that they conduct themselves. Nobody wants to be in an industry where there are cheaters who are getting ahead because of their cheating. And it's the same thing with, I think more people would be supportive of whistleblowing if they fully appreciated that the work of the False Claims Act is to put money back into taxpayer funds. And so it's all of us that are funding the fraud that occurs. So when money is, taken from the Medicare and Medicaid program that we're not, that we're not compliant, or for the services that were not performed, and the same with these massive DoD government contracts where services are not being performed properly, or the proper products are not being provided, the taxpayers are paying and making up for that. Every one of us ordinary Americans who aren't getting some enormous tax break are the ones paying for this. And so whistleblowers help to expose that and send the money back to the taxpayer funded program, because if any of these programs like Medicare and Medicaid, they could become insolvent. And if they do become insolvent, we have the only, real option we have to replenish them is to bring back in the money through the False Claims Act. That's the big.
Yeah, that's a really, really important point. It is a truly bipartisan law. And in fact, one of its biggest proponents is a Republican, Senator Grassley, because the intention and the expectation is to stop the spigot, to stop the spending. So, it really, and by default, to stop, excessive taxing and whatever, because we're already being very conservative with the government funds that we have. The irony is that it's the private industry that really takes advantage of these government funds. And that is why the government is in need of people who have information, knowledge, whether it's insider information or data expertise. I think it's really helpful, Renee, that you remind me of the Madoff whistleblower, because he's a great example of someone who was not an insider. He was not a traditional insider, but he had an enormous wealth of knowledge of this massive scheme, this massive Ponzi scheme that really affected people's lives, their everyday lives. They had no retirement funds. They were completely wiped out. When you think about that, I mean, that's borderline, criminal activity, and yet he wasn't considered, and he wasn't necessarily listened to in the first instance because he was not a traditional insider. So part of Renee and my role is to help really kind of, what's the word I'm looking for? I guess just revamp the way that we think of whistleblowers, and just rethink this space, both because of the enormous negativity that has historically attached to whistleblowers, and also because of the significance of their work. I mean, Renee, can you, just briefly speak to why can't the government just do this themselves? Has the government attempted to identify, where funds are going and whom funds should not have been paid to? Why can't the government just figure this out on its own, or has it?
Yeah, I mean, there are, the government has some helpful tools, like it has a lot of Medicare and Medicaid data, for example, where it can target red flags. So they can look at the Medicare and Medicaid data of healthcare providers, and if they see the largest, dermatology spender of Medicare money in the country is some one single doctor office in some small town in Oklahoma that has like 1,000 patients, and they are spending Medicare money off the charts, that would be a red flag, right, for the government to say, ding, 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 wait a second, how can that one doctor in that one small town who's a specialist in dermatology be submitting all of those claims to the Medicare or the Medicaid?
They all have bad skin in Oklahoma. That's what it is, Renee.
So that's like a big ding, 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 a big ding, ding, red bell, a big red alarm. And so, however, they don't have any knowledge. It's just a red flag. It's just a red alarm. Who knows how many, maybe people from 3 neighboring states are going to this fabulous specialist, and that's why the claims are, so high. So they don't know. They can have red flags, but they really don't know what's at play, what is happening inside. They don't have any evidence. And so, as I like to say, no different than, barging into somebody's house without probable cause, without a reason, without a search warrant. DOJ isn't going to just barge into all of these businesses and say, we're conducting an investigation on little to no information. So they really need the information of someone who is inside the company and who has documentary support, or they're in this hot seat, as I like to say. They're the person in the hot seat. They're the ones who are aware that they're working with the dermatologist. They may be the only employee at this dermatology practice, and they may say, I know, we have one patient come in and we bill them for 20 services, and I only provided one service to the patient. And I know that we're billing, our medical record says that I gave them 20 services and I didn't. So we need that kind of extra information, even though data analysis is very helpful, and it can help to refine an analysis. It can help to develop damages. It can help to target concerning practices. But it's not enough information for the government to really go in there and feel comfortable that it can conduct a full-scale investigation without whistleblowers.
It's one piece of a puzzle.
And a necessary piece, I would say.
Absolutely.
Yeah.
I mean, it's a central piece, but the relator provides the government with some other pieces of evidence that the government otherwise wouldn't be aware of. I mean, another good example is in the anti-kickback context. You can see excessive claims for a drug, for instance, from a physician practice group, but it's the relator who's telling you what the remuneration, what the compensation is that the physician practice received from the pharmaceutical company, whether it was free lunches, whether it was free use of software, whether it was free personnel or free space. The government can't know those facts. And even just any one of those facts coupled with the excessive claims for the drug, that's an anti-kickback violation, just, on paper. And so that is really the significance of relators, bringing information, non-public information that the government otherwise wouldn't be privy to. And the government encourages it. The Department of Justice has a whole unit that is devoted, and it's the unit that Renee and I came from, devoted to the enforcement of this one law. That's how important the government views the enforcement of False Claims Act violations.
And every U.S. attorney's office in the country,
that's right,
has one or more prosecutors that are devoted to False Claims Act enforcement.
That's right.
So this is really the government's primary tool to recover misspent money and put it back into the programs where the money was, taken from. So the last one initiative that I want to talk about is the Civil False Claims Act Cyber Security Fraud Initiative that DOJ has. This is a brand new initiative. It's been around several months, and DOJ at the very highest levels of DOJ have announced this initiative, and they are calling all whistleblowers. They are looking for anyone who has knowledge of a government contractor. So either you could be a competitor, more likely employees within government contractors are going to be the right kind of individuals with knowledge of cybersecurity violations. So if you are working for a government contractor and there are cybersecurity violations that the government contractor is well aware of, that they are ignoring, they aren't trying to comply with the cybersecurity requirements, or they're incredibly lax about their cybersecurity, or they have had breaches that they are not reporting to the government. They have had compromises of government information or government secret projects that they are responsible for. That could be a potential False Claims Act violation, and then obviously can be a serious implication for the United States, because now, this initiative arose out of the SolarWinds incident and is really a product of the United States being very concerned about Russian hackers. And of course, there's lots of other hackers, and there's US-based hackers as well that can be stealing information, but it's really an international threat, is very serious concern to us right now. And so any cybersecurity protections that are not being taken on behalf of government information under any government contract, because in almost all government contracts, the contractor has information of the government in its possession, or secret programs that it's working on for the government that needs to be protected. And some contractors, because we've been talking to whistleblowers, have really failed in even basic cybersecurity requirements, including the requirements in their contracts, specific requirements, NIST standards, Department of Defense, Federal Acquisition Regulation standards, and any breaches that occur where it's not being disclosed to the government. So if you are an employee of a government contractor and you are aware of that your employer is knowingly providing cybersecurity products or services that are deficient, knowingly misrepresenting to the government at the time of contracting what your cybersecurity protections are. That's a second type of False Claims Act cyber fraud case that the DOJ is interested in hearing from you. And also knowingly failing to disclose to the government when you actually have a breach or a serious incident that may have compromised or did in fact compromise government information, and you have not disclosed that to the government. So those are the kinds of cases that DOJ is looking to enforce under the False Claims Act. And if you have that kind of knowledge or information, the government is very interested in you, and you should reach out to an experienced False Claims Act attorney who knows how to, put together that package and reach out to the government and help the government with that investigation and help you through the process. And so we're going to talk on our next episode about more initiatives. And there's a question. Eva, do you want to take another question?
Yeah, sure, we can.
Yeah,
I had a quick question for you. Can you just give us really briefly, what is a real world example of a cyber incident? Like what would, something that your family could understand?
Oh, we've seen some really basic things, haven't we?
Mhm. Exactly.
I mean, some basic cyber incidents or cybersecurity violations that we've seen are companies that don't require employees to have their equipment password protected, or allow their employees to work at home, which we know most people are doing now in the post-COVID environment, but without any security protections on their computer. So some of the cases we've seen, they don't even have the basic software that, like, for example, my husband put on my personal computer at home, just basic consumer
Right.
types of protections on computers. Or you work in a open space and there is no, what I call, timing out of your computer. So
Right.
you walk away, you go pick up lunch, and your information is still there because it hasn't timed out in 10 seconds when you've walked away from your computer.
Yeah,
So
I was shocked. I must say, Renee, and this kind of goes along the lines of our experience in the compliance space as well. It still surprises me that there are companies who don't have some of those basic cyber protections, and also don't have certain basic compliance measures in place. Things like a whistleblower program, an ombudsman, a process by which somebody can make their concerns heard. And likewise, everything that you relayed in terms of failure to time out your session, no password protection. I mean, you feel like these are pretty basic things that we understand and we protect on our own home personal laptops. And yet there are large companies who are still failing to take those measures. And even if they didn't mean to, i.e., they just didn't have the time or they didn't want to spend the money, that's still a False Claims Act violation, because it's called what we know as reckless disregard under the law. It's still a violation of the law if they don't take the time and spend the money to provide those protections for government information on government contracts. So I think that's really important. The final question we have is, we've been talking a lot about healthcare and cybersecurity and government contracting, frankly, but what kind of fraud out there, what kind of other fraud is on the rise? And I would say I would have two responses to that. And Renee, you should definitely chime in with your thoughts. One is kind of along the lines of cybersecurity, but a little different. Electronic health records is huge. We now have government initiatives to encourage companies to move to what we call EHR, electronic health records, or EMR, electronic medical records, because frankly, it is a better way to store everyone's health information, which is vital. But there needs to be certain ways in which you do that, and certain protections that should obviously be afforded to your personal identifiable health information. And those protections are not always being afforded that type of information. So that's one huge area. And then another that I think hasn't really gotten enough attention in the right way, I should say, is I do think there's still CARES Act fraud out there. And the CARES Act was the big legislation that was passed after COVID really hit, to help businesses and persons cope with the difficulties that attached to the pandemic. I'm not talking about the Personal Paycheck Protection Program, or PPP. I'm talking about all of these other contract awards that were given out to big companies to help everybody with PPE, the personal protective equipment, to help with updating HVAC units, to help the airlines with their air filtration systems. Those kinds of contract awards were awarded in a fairly quick way. And so I do have serious concerns about whether that money is being spent in the way that the government intended. Renee, you may have your own thoughts?
No, I think that's excellent. And I think that concludes this episode of Office Hours with Whistleblower Attorneys. I'm Renee.
I'm Eva. We hope to see you next time.
Thank you. Thanks for joining us.